All right. Anyway, I'm going to introduce my guest right now, and my guest is John Myser. And you also happen to know Michelle McDonald, don't you?
I do. She's been my attorney in my family law case.
Okay. And you brought up something interesting on this, is that, well, my understanding, she was in a holding cell the whole time.
Right. She was in a holding cell when they took her in there, and then when they kept her overnight, Tim, they removed the mattress from the cell.
Oh, the holding cell had a mattress?
They removed the cell, they removed the blanket, they removed the pillow, and they left her in there with nothing. And mind you, they put you into like the jailhouse clothes, and they didn't even give her like shoes. So that night, while she was in the holding cell, she was freezing cold.
Sure.
So what she did is...
and that's, the jails are cold.
Yeah, the jails are cold.
Yeah, definitely.
So here she is, she's freezing cold, so she saw, what is in here? How do I keep some warmth? And she saw the toilet paper over there. So she took the toilet paper and she wrapped her feet. She wrapped her feet, and then they have these very bright fluorescent lights that are on all the time. And then so she wrapped something so she could get some darkness to shield herself from these super bright lights.
They do dim them at night.
No, they don't.
They didn't do it to her?
No, they kept them on the whole time.
Okay.
So she did this, and then one of the police officers came in, or bailiffs, or guards came in and said, "That's an improper use of toilet paper," and took it off her feet and took it off her eyes, and said, "Don't do it again."
Huh.
Well, she was shivering and shaking, and so she did it again.
Yeah.
And a little while later, this guy comes in again and says, "That's it." Takes it off her eyes, takes it off her feet, takes the toilet paper out of the.
So she has now.
So now she has nothing. And, she reports, she had to, use the bathroom later on. She had to ring for medical, for people 20 times till they would finally come in and bring her some toilet paper so she could clean herself.
Uh-huh.
So she'd go to the bathroom. So she just described this. And I thought, oh my God, are we in Nazi Germany? What's going on? I mean, it's kind of crazy.
People don't realize this, and they need to, but we are very, very close. Where Nazi Germany went through the whatever program they went through to get where they are, we're only about 2 years away, in my opinion, because a lot of this activity is happening. People don't know it's happening,
right.
and there's a deniability to it, and they just don't get it. Right. And actually, a lot of people went through the war and never understood it, and that's why they marched the people to see the death camps, and then they go, "Oh my God, we were doing this."
Right.
And that type of activity is going on. We don't have the death camps, but we got terrible treatment of people who haven't even been charged with anything, haven't even been told what they're under arrest for.
Right.
Unbelievable.
Right.
Well, let's get into your stuff here, because so, I mean, Michelle McDonald comes into play here because she's helping you on an appeal. But we're going to talk about oath of offices, and you found a judge that did not take their oath of office. But before we get into that, I want to lay a foundation of what got you to find out all this information. So how did your process get started with the courts?
Okay, so I'm a litigant in a family law dissolution case in Scott County.
Okay.
And
Scott County?
In Scott County.
Okay.
In Scott County, in the 1st Judicial District.
Okay.
With the judge presiding over our case is Judge Carolyn H Lennon. She was appointed by Palenti in 2008 and elected in 2010.
Okay.
So before Judge Carolyn Lennon, and I noticed right away that this judge was biased. There were a number of incidents that just started happening. Like right away, she ordered child support. There had been no motion, no hearing, no nothing, but ex parte communications by the opposing attorney.
So there was no pretrial?
No. Well, there has to be a motion.
Right.
There has to be a motion in order to have child support, and there was no motion.
So were divorce papers filed?
Oh yeah, there were divorce papers filed and a counterclaim, and they have this initial meeting called an ICMC meeting, called the initial conference meeting. And at the initial conference meeting, no orders shall issue unless by agreement. So nothing adversarial.
Right.
Whatever
you agree to
goes through,
and the rest gets...
So all of a sudden, after this initial ICMC meeting, the opposing attorney, Brian Sobel, starts writing email communication to the court, to the judge, copying me.
Oh,
but that's classified as ex parte communication.
He didn't Did you have an attorney in this, or did he?
At this time, I was pro se.
Okay, so he copied you.
So he copied me and went in there and started saying, oh, I forgot about the child support. I forgot to do this. I prepared a child support guideline worksheet, and I've plucked a number out of thin air, and on a joint tax return, I've attributed all income solely to the father, and then I came up with this calculation that the father owes $1,028 a month.
And you...
With no motion,
And
no hearing, no agreement
you guys
over
didn't
my
even-
objections.
You guys didn't even talk about this in the
No,
ICMC meeting? Okay, wow. Okay.
So I just kind of get lambasted, and so I started filing objections to
But the
this.
attorney said you did.
No, he just
He
said,
didn't even say-
he created it. He created the, and said, oh, I forgot to get back to you. I've been so busy, and here's the information. It's as if he had communication with the court
Uh-huh.
and was signaled to do this.
Oh, okay.
So it was like, 2 weeks later, it's like, oh, hey, Judge, sorry, I've been really busy. I forgot to get back to you. Oh, and here's the information I promised you during our ICMC hearing. I was like, where's that coming from? Right?
The information I promised the judge. Well, who was at the
ICMC
initial-
hearing would be my wife, my
Yeah.
estranged wife, myself, and her attorney, and then the judge.
And the judge was there.
And the judge was
Judge
there.
Lemmon was there.
Judge Lennon.
Lennon.
Judge Carolyn H Lennon.
Okay.
Yep.
All right. So the judge orders this then.
Orders this over objections with no motion, no findings of fact, no nothing. Just does this. I mean, so that starts off the case. So
Oh,
we're
wow.
leading up to how do we get to
That's pretty bad.
a recusal motion. Well, and then a few months later, after trying to stop this and, this craziness with her, and she just continues, I wanted to take my son to Palm Desert, California, to his grandmother's house because we were selling it.
Okay.
And it had been a place that he'd been before
And
for
that-
Easter and a family home.
Already been there.
Already been there. So I make a motion to the court to take him there.
Right.
The order comes back from the court, and they have a thing called the findings of fact.
Right.
And they go, you're not allowed to take your son to Florida, and you're not allowed to take him to a place that's unfamiliar
Okay. In the findings of fact.
in the findings of fact. So
Yeah.
therefore, I'm denying your ability to take your son on, for a vacation.
Right.
So I'm kind of going like, what judge was I before? Because I said California, not Florida, to a familiar place, a grandmother's home, versus Florida to an unfamiliar place. Mm-hmm. I'm wondering what case is she paying attention to?
Huh. Well, could you then have gone to California because she said you couldn't go to Florida?
Right. That would be kind of fun, but so I was denied I was denied to take my son.
Okay.
So after about 50...
Which a lot of judges do this because they're just bad. I mean, they're just mean. There's
Yeah.
no reason to not let a parent take a child to another family member's place. There's just no reason.
Before this whole thing started...
No allegations of abuse?
No allegations of abuse towards the child, none. And before
or
this
the
even
spouse?
started... Oh yeah, it started off an attorney-driven strategy.
Okay.
An attorney-driven strategy of an order for protection, alleged criminal charges. I had no prior history, no record, no police calls ever to the thing. And next
Okay.
thing you know is this attorney-driven strategy is employed where I'm bounced out of the house. She gets control of the house, control of the child, and diminishes your standing before the court.
Right.
Because what judge, on the thinnest of allegations is going to say, well, we got to be there for safety. Mm-hmm. Right? Even though it's like, So anyhow, that starts this whole...
Well, and anybody that's watched this show knows that and if attorney doesn't do that for a woman, they'd be guilty of malpractice.
Right.
That's what I say. They shouldn't be. They should be having their license
Right.
and being disciplined by the Lawyers Responsibility Board. But again, that's a high hurdle to overcome, but needs to at times. But you got to have a lot of money to overcome those type of allegations. A lot of money.
Well, and a lot of persistence in that, because I've already written 4 complaints to lawyers' professional responsibility. 2 complaints I've gone to the Judicial Standards Boards, 2 by other people that have supported me, a woman by the name of Kim Buckstein, who's a civil rights advocate who's very good at writing complaints and petitions. And these people have a club. They kind of protect each other. It's
sure.
hard to, even with these petitions, I mean, if you look at the desk here, a lot of this stuff are my petitions. I've got stacks like this of petitions I'm going through. So, we come back to how'd this all start. Well,
Right.
I have some premarital property. So this is a way to, for the attorneys to
To
go
break
in and to
in.
try and break in and try and invade premarital property.
Right.
So, and the judge, in this case is going, well, I could just sense the bias. So in December, we put together a recusal motion with about 50 different elements of bias in the case that had happened from the start of the case in April 2012 to December 2012. So in about a short
When you
7
say
months.
we,
My attorney, this
Okay.
time Michelle McDonald, had joined me
Okay.
and helped put together my recusal motion.
oh,
And so we put together a mammoth recusal motion to remove the judge and filed it December 22nd, 2012.
50 issues on there.
50 issues.
Wow, I mean, that's a lot.
50
And that
individuals
judge
from the
is-
record.
And that judge is supposed to go through each and every one of those.
As clear as California and Florida. Familiar and unfamiliar.
Yeah.
Those kind of black and white issues.
Right.
Where's this judge paying attention? Is she watching Judge Judy while she's sitting on the bench watching her case? Who knows where this woman is? I think maybe, she might, well, I don't want to speculate, but
Well, yeah.
there's a problem
So
following the law.
So you filed these things with the Board on Judicial Standards, complaint against the judge, Professional Lawyers Responsibility Board. What kind of response did you get from?
Well, the Professional Responsibility Board was, they denied my initial complaint and just said, doesn't rise to the merit. And this is when I started to talk about the oath. So I got to get to that part to tell you how we got to the oath.
Okay.
So why don't do you want me to go
Well-
there first, or do you want me to talk about the complaints?
Well, then, after you filed the complaints, did you file the recusal, or did you file the recusal before?
First, the recusal.
You did the recusal first. Okay, I wanted to finish that.
Yep.
So when you did the recusal, she has to respond to that, and then did she respond, and how did she respond?
Okay, so filed the recusal December 22nd. We have a hearing January 22nd with the judge. So I filed the motion, in all the proper time. And in there, I decided to find out, that if the name of the game is break a rule and pay, right? If you break a rule, you pay. So what are the rules? So a friend of mine said, why don't you go see what rules apply to the judge and see if they're breaking rules
Okay.
that apply to them.
Okay.
So what that led me to do, Tim, is I went to the Secretary of
State's
of
office.
website, because that's
Yep.
where a judge files an oath. And so there's a document like this that
Okay.
that where you can make a request of the
right.
of the Secretary
Let's
of State.
put that graphic, there it is, there.
So there it is. So there it is on screen, and over there you can see
It's
December
really
26th.
simple. You just basically put a date, check a box, and
What district?
Say who you
so I
are,
said, what
or what
district? And then
judge.
it's like, okay, what year was she elected? 2010, because she was appointed just 18 months earlier.
Uh-huh.
And I said, I want to get her elected oath of office for 2010, because that'll carry her all the way through 2016. That says
Mm-hmm.
that she's constitutionally authorized to preside and adjudicate. And
now,
can you do it?
I want you to know, I've also filled out this form.
Okay.
And I noticed you got charged $5. And I told them, I wanted a certified copy, and they charged me $6. And I said, the form says $5. Why are you charging me $6? Because it's $1 for the copy, and it's $5 for the certified copy. Yeah, but the certified copy is one. It was just crazy. I mean, it says, no, it's just $5. and yeah, who's gonna, I'm not
Right.
gonna argue over it. I just couldn't believe what was going on.
Oh, that's
But-
goofy. Well, I actually went
but-
through and I got all the judges' oaths from First Judicial District, 35 judges.
35 judges you got all their oaths.
All their oaths.
So
Well,
you-
I filed it because I wanted to find out what they had. No, I got just copies on the rest, but I got a certified copy for Lennon. 'Cause I thought,
Okay.
I want that one to be special. So if we flip to the next page,
All right.
on January 2nd, I get a response from
Right.
the Secretary of State office that says, oath for Carolyn Lennon, not found.
Wow. That is a huge mistake. I mean, that is egregious
Right.
mistake by a judge. This is something that they are trained to do. Once they get elected or appointed, they have their training. They say, do this. You've
Right.
got to do this
Correct.
right away.
So the key word here is they've got two requirements. They've got to take an oath and they've got to file an oath.
Right.
So the only evidence I have right now in hand is she hadn't filed her oath. Right?
Right. She
And
could have taken it.
She could have taken it, but failed to file it.
Right.
And legislative statute 358.11 says you are mandated to file. So the legislature has imposed a duty upon the judicial officer, you shall file.
A mandate.
350, a mandate, 35811. So right now,
it's
the
a
judge has broken that mandate, and that's a misdemeanor.
Yeah, okay, so then it's a ministerial duty, it's something they have to do, and if they don't, the
No
law...
discretion.
The law says, what was it there, 358.11 says it's a misdemeanor.
Right, because there's a blanket thing in the criminal code, 60943, that says for areas where penalties aren't prescribed, where there's ministerial duties and there's been neglect, misdemeanor.
Okay.
Public misconduct, 60943, public misconduct.
Misdemeanor, that's an
Misdemeanor.
impeachable offense, too.
Impeachable offense.
But in this case, if a judge doesn't file their oath of office,
Right.
is there something else that happens, or?
Well, so basically now we have the recusal hearing on January 22nd, and I don't have evidence that she hasn't taken an oath.
Yeah, okay,
I call up the Minnesota Secretary of Office, I call up Nancy Bream there, who's the person who does this, on the morning that we're to have our hearing, and I said, hey, is there an oath of office in for Carolyn Lennon? This is January 22nd. She goes, no oath of office still. So I'm going before a judge where there's no oath of office on file.
okay.
So I feed that information to Michelle for our recusal hearing, and basically what happens during that thing, Judge Lennon, his demeanor was hostile and attacked Michelle, didn't like our recusal motion, didn't like the fact that she'd been called
Irrelevant.
out. Irrelevant.
Irrelevant.
Whether
Whether you
but she was
like
just
it or not.
really hard on Michelle that day.
Oh, my goodness.
And we had notified her. How did the judge know she had no oath on file? Because I had filed a supplemental affidavit on January 11th.
Okay,
And I said, hey, you have no oath.
plenty
Get
of
off
time.
my case. You're not qualified
Okay.
to preside.
So she says no.
She says no at the recusal hearing. She says, I'm good to go. My orders are good. I'm good. I'm a qualified judge.
But you still have all those other issues. That was just that one issue.
And then she said those issues don't rise to the level. You know, California,
Okay.
Florida, who cares, John?
Standard procedure. A judge is going to do that no matter what. They're going to make you go to the next level.
Isn't that kind of goofy? Could you imagine, a hockey player reffing his own team's game and not a ref? Would you think there might be a little bit of problem? Who guards the hen house?
Big problem in the courts. That's why you get to appeal their decision. Okay, so
Right.
you have the right then to go, and my understanding, the chief judge in the first district is
Edward
Lynch.
Right.
Lynch.
Was. He's now retired. Just, August 30th.
Really? How
Yeah.
old is he?
He's young. He's in his, late 50s, so he's a young judge. So it's kind of interesting he retired.
That's a rare thing.
Right.
It's normally a pretty cushy job.
Yeah.
Because nobody pays attention to the judiciary.
Right.
But here, Lynch is all tied in with the Carver County women. Of course, Leah Bankin's been on this show, and there's 5 women that have just gotten creamed in Carver County, and Lynch has been, in my opinion, covering up for the judges. So you then appealed to Lynch.
Appealed to Lynch, February 7th. He denies it.
Okay.
Okay, he denies it.
Standard?
So, standard denial, really quick, says, doesn't raise, and says, she's...
Didn't say why it doesn't rise.
Cited two Minnesota cases, Huff Sauer from 1955 and Smallwood versus Wyndham from 1915. I can distinguish them really quickly if you want.
Sure.
Huff Sauer is basically about citizens on a police tribunal that were required to take an oath of office to be constitutionally authorized to be there. Citizens, right? Citizens, not a judicial official.
Right.
Citizens. So they kind of said, oh, you know what? They goofed. Let's just make their rulings good to go. They're good. They just made a thing. We'll let them go because they're not, they're not
Yes.
educated in the law, and this was a goof.
Okay.
Then Huff versus Smallwood versus Wyndham is about 2 judges back in 1915 up in Duluth. And they ran an election. Wyndham was the incumbent, Smallwood was the challenger. Smallwood won, but it was called a preferential election, and Wyndham challenged it. So first of all, what happened is Smallwood takes an oath
Okay.
and gets qualified.
Okay.
Wyndham says, hey, I'm leaving the office. I'm not going to fight with you here, but I'll leave. But I'm going to challenge you. So let you know, I don't think I should have to leave. I should get a holdover provision. Challenges the election. The election is found to be bad, so they throw out the election.
Wow.
And Wyndham goes back in, takes the oath of office, swears an oath.
Okay.
All right? So he's qualified. The governor gets into this horse race and appoints Smallwood to the
Wow.
office because there's a constitutional issue. You can't be in office for longer than 7 years. Wyndham, on his holdover provision, would have been there 7 years, 2 weeks.
Okay.
So Smallwood raises this issue all the way up to the Minnesota Supreme Court. Minnesota Supreme Court says, you know what? Can't violate the Constitution. Wyndham, you're out. Smallwood takes another oath of office to qualify,
Sure.
right? Now that it's his appointed oath. He took an elective oath, but these guys take an oath. And in
Right.
fact, they even write on their oath, they wrote even higher standards, fidelity, that they wanted to
Right,
treat the oath that
right.
was sacred to them back in
Right.
1915. Well, Lynch cites this case because the Supreme Court said, okay, now what do we do in 1915 with this little brouhaha we had, and both judges sat there and they both made rulings. Well, they said, you know what, they both swore oaths, they both were there, let's just say the cases were good, we'll call it they were good to go. So we're not going to re-adjudicate those cases. And they call that the de facto doctrine.
Okay.
So they let him go. So Lynch cites these two cases as applying to my
Sure.
case with a judge who failed to take her constitutionally and statutorily mandated duty to take an oath
Yeah.
and file.
Where these guys actually took an oath.
Took an oath. And he said these cases apply because
Yeah.
they're the same. Well, they're not. They don't. There's a rule that the Supreme Court has to follow. It's called an authority not embedded. A rule not embedded doesn't apply. So it's
Right.
got to have the authority
Right.
in there for that case. So it would have had to been the judge didn't take an oath for it to apply to be de facto. Does that make sense?
Sure. Yeah.
So
Well, okay, so Lynch does this thing, and
and at this point, I still don't know if she's taken an oath. All I know is she hasn't
okay.
filed.
Okay.
So what do? I go back to the Minnesota Secretary of State and I think, you know what? Let's go ask him. Maybe she's got an oath in there
All right.
now. Well, it comes back. She does. She has an oath and it comes back. And there it is. Notice the date she takes her oath. January 18th, 2013. That is just 4 days before my recusal hearing and 7 days after I notified her by my affidavit. Judge Lennon was to take her elective oath of office January 4th, 2010.
Right.
How many years is that, Tim?
Well,
3 years.
3 years, yeah.
And how many
Thanks
weeks?
for helping me with
2
the
weeks.
math.
3 years, 2 weeks. This
Yeah.
judge is without an oath.
Right. Now, if you're without the oath, isn't that office vacated automatically?
That's a beautiful question. Look up statute 351.02, and it's titled vacancies. And there's a number of issues. The office shall be vacant upon these conditions. 351.02 states,
Right.
sub 6, if the judicial officer
Dies?
neglects or fails to
Right.
take the oath, the office is vacant.
Is vacated, right.
It's vacant.
Vacant. Well, but I was reading the statute, and that is in context of the officer, or the judicial officer's dead. The officer is moved out of district.
Right.
The officer, three things that are just like solid. I mean, they're not a judge anymore.
Right.
Convicted of a crime or something,
Right,
impeached
right.
or whatever.
Exactly.
You have it there?
Yeah, I've got it right here.
Okay.
Right.
Well, read the first four.
Vacancies. Every office shall become vacant on the happening of either of the following events before the expiration of the term of such office. So for Lennon, that would have been 2010 to 2016.
16, right.
So what are the conditions precedent? The death of the incumbent,
Okay. And you need a new judge.
the incumbent's resignation,
Okay,
the incumbent's removal, right?
right,
The incumbent's ceasing to be an inhabitant of the state,
Okay.
and move away.
yeah,
The incumbent's conviction of any infamous crime or any offense involving a violation of the official oath. Right? Right? Aren't you required to take an oath of office to support people's secured rights?
so infamous crime,
Right? And then the last one, number 6 here, or actually 6 is the incumbent's refusal or neglect to take the oath of office.
or neglect.
Or neglect to take the office, or to give or renew the official bond, or deposit or file such oath or bond within the time period prescribed.
Here's what's interesting about the wording, refusal or neglect.
Neglect.
What's the difference between the two?
Well,
You can't know. You can't know the
I
difference.
don't know what she did, why she didn't take
Was
an
it
oath.
refusal?
I don't know. I don't know if it was refusal or neglect.
So that's why they put neglect in there, because it just doesn't matter what it is. You didn't take the oath, you're out.
Right.
You didn't do your job. The office is vacant.
Right. That's a beautiful question.
Because the oath is so important. The oath is you're swearing to whoever, at one time God, that I'm going to do this way and I'm going to behave this way in my office.
Right.
And it's a way to hold that individual accountable, not only to the citizens, but to God themselves, And so you can't, in a criminal action, you can't say, in order for something to be criminal, you got to prove intent. So how do you prove intent that somebody is refusing to sign an oath of office? You can't do it, so they just say this doesn't matter.
Doesn't matter. Neglect.
Yeah.
And then all of a sudden now, she surreptitiously files an oath 3 years, 2 weeks later when she's been called out.
Yeah.
And said, hey, get off my case.
Right.
How many cases do you think that she's presided over where maybe there's a criminal defendant over here and there's this type of case? I mean, we've got the state, well, we can get into the state versus Irby, which is where a judge didn't reside. How many criminal cases have appeared before Carolyn H Lennon during these 3 years, 2 weeks when she wasn't authorized?
Right.
She wasn't
The
authorized.
office was
She is
vacant
not, the office, she
Was
never
vacant.
qualified, vacant.
while she was there.
The Attorney General issued an
Okay.
opinion in 1978, December 26, 78, when Governor Rudy Perpich asked Warren Spanis to determine when do you need to take the oath of office. Because that first January in 79 was on New Year's Day, January 1st. And you had Alan Page coming in and you had the old one going out. And
Okay.
there was a little bit of an issue there, when do you got to do it?
Right.
And they said, on that day or before.
Right.
As soon as possible. And if you
Okay.
don't do it and you're there as a holdover provision or whatever, all you can do, de facto wise, is ministerial duties, nothing serious. And so December 26, 1978, Warren Spanis issued an opinion and said, you got to do this.
Yeah. They have to sign, and they got to do it at a certain time. Definitely. Here's some
Right.
more
Water,
liquids
thank you
here.
very much. Appreciate that.
So,
So why would a judge fail to do it? And what's really troubling, Tim, is so we get back to, so then I filed a letter of reconsideration with Lynch with this new evidence.
okay.
Lennon filed an oath. I now have the evidence she was without an oath for 3 years, 2 weeks, and I gave it to Lynch on what's called
Which
a
is
letter
very
for
ni-
reconsideration.
It's a very nice thing to do.
Right.
It is.
Right, to advise him, hey, you made a mistake. You thought maybe she had taken the oath. She just didn't file it. So it wasn't as egregious. Well, now we've got the evidence she didn't take.
Yeah,
She
well,
was not a-
for
and
Lynch to
Lynch-
say it wasn't egregious is just
Lynch took
outrageous. Anyway.
Lynch took about 7 minutes to deny our letter for reconsideration because it went in by email and he turned it around and said denied.
That's all he said?
Denied.
Did he
Denied, denied.
Standard practice.
Standard practice.
He didn't, yeah, he probably read it, but didn't care.
Denied. It's all right. We don't
Okay.
need to.
So-
you don't
so-
have your insurance card in your car and you get a ticket.
Oh, yeah.
Right? We got to
Money.
follow the laws, but apparently they don't.
No, they don't, and they know that they don't, because nobody's holding them accountable. Nobody's
Right.
watching them, and I'll be honest, they know this, I know it, the legislature's too afraid, and there's too many legislators that are attorneys that want to be judges.
Right.
And they hold the key, that Supreme Court holds the key to their license.
Right. And do you know when the last time the House used its power to impeach a judge? Do you know how many years it's been?
Well, it's been a long time, how long?
Try 130 years.
130 years, so.
So I guess we got a lot of good judges. Right? We must have a lot of good judges, no corruption for 130 years.
Yeah. Yeah, like Michael Silvis. So let's see,
So,
you then, after Lynch gives this denied,
right.
what happened?
Well,
Did you
then-
appeal that to somebody
Yeah,
else?
so then we appealed that. We did a thing called an extraordinary writ called a writ of mandamus at the
Okay.
appellate court.
And they don't like those.
And they, they're
Because it
expensive.
stops the process.
It stops the process, and
It
they're
absolutely
expensive.
is expensive.
To get
$500
justice,
filing fee. and
$550.
$550 now,
$550,
right?
$550 to go get justice. Even though our Constitution says justice shall be free and without charge, big problem there.
What's a whole nother issue that needs to be challenged in our courts. And
right.
unfortunately, the attorneys that try to challenge that get beat up.
And so do the litigants.
Yeah.
Because if you know that I was incarcerated as well.
Okay.
And we can go back into that. So I filed, that was when I filed my petition to the Supreme Court. So I filed this writ of mandamus with the appellate court, and within 6 weeks later, the appellate court, and it's really interesting now, they use this electronic signature. They don't even get a real signature of the judge. So I don't even know if the judge, I mean, that's kind of weird.
It's just terrible.
It's really weird.
outrageous.
So they got this thing, and I get an order back from the appellate court May 22nd denying my case,
Mandamus.
my mandamus, and they said,
Okay.
you know what, you didn't do a very good job of distinguishing, your case. Judge is good to go. They don't need to take an oath.
Distinguishing, did they say what distinguishing meant?
Yeah, distinguishing from Huff, Sauer, and Smallwood, Wyndham.
Oh,
You
okay.
didn't just, those cases apply. Even though there wasn't a judge with a lack of oath, there were different principles in those cases.
Sure.
They say that,
Okay.
they pull any case off the
Well.
street and say it applies.
All right.
So anyways, they denied that on May 21st, and it's this electronic signature, with two
It's just
slashes and an S.
Backward slash, S, backward slash.
And
then
it says
the name
Matthew E.
in there.
Johnson.
Right.
I don't even know if he read the case,
Yeah.
right? I mean, this electronic signature, so it just leaves you feeling a little weird. So
Yes.
I,
Absolutely. I think this is a bad system. You know what? They could photograph a signature. They can
Right.
put a signature on there. Well, did somebody sign this?
that's my 6-year-old, Tyler. He was playing on that, so that was my photocopy, and he got on that.
All right.
Right.
Okay, so
So then we filed the petition for discretionary review to the Supreme Court. This
Okay.
document right here.
All
Look at
right.
that. All this here, 100+ pages,
all right.
and essentially it just says, judge has got to take an oath. I got what's reigns supreme? What's the supreme law of the land? Mm-hmm. Well, is it the Constitution? Mm-hmm. Or is it a bunch of judges creating case law or de facto doctrine, as they like to call it?
Mm-hmm. Right.
Do they reign supreme over the Constitution?
Right.
So this is it. The Constitution says you've got a mandate to take an oath. The Minnesota legislature has defined you got to take an oath.
Right.
They've said when the office is vacant if you don't take an oath.
Right.
And then you got the judges refereeing themselves saying, no, we're good to go.
Right.
So the question before the Supreme Court, which is our
Did
court of record.
they even acknowledge that she didn't take an oath in the appellate court in Lynch? They didn't even acknowledge it.
No. And you know what's kind of weird? If you notice on my petition to the Supreme Court, and I should have had a copy here, but this is what they call the caption page. So I don't even know if we can get that, but this is the caption page. So it's John Myser, petitioner, versus Carolyn H Lennon, judge of Scott County District Court, respondent. Right? And it has to be within the marriage of my ex-wife and I, my estranged wife. But I name her as the respondent. Well, when the order comes back, they hide it. The Supreme Court, the appellate court, they pull it off.
They sure did.
They cover it. So they provide this cover for the judge by not naming her, so it doesn't make it easy to look up. So they kind of hide this stuff. Why do they do that?
Absolutely. I mean, that's my pet peeve. I've talked to the legislature about this. I says, these judges write these orders, and you don't know what judge is on that case by the order. They're on the top of on an order, if you got one there,
Right.
it should list every judge that was on the case and how they decided. But you only get the name of the judge writing the opinion and the name of the judges if they don't concur.
Right.
Or if they write something, or if they concur and they write something.
Right.
And so you don't know who the judges are in the case, which is ridiculous to me. It's just terrible. There's so much lack of transparency in the courts on these judges, and
Right.
so much hiding. They know it.
They won't let you take
this scam.
photographs. They don't let you do your own
Yeah.
recordings. They don't do it. But so anyways, back to the case.
And we got about 5 minutes left, so we're going to have to
Keep going fast.
It's like the 2-minute warning.
Okay, got it. I was
We
kind of
gotta-
looking there.
We got to go fast here.
Okay, so filed the petition with the Supreme Court on June 21st.
Okay?
Okay?
And they don't have to hear it.
They don't have to hear it. They don't have to accept it. And they did. They accepted my petition
Okay.
August 6th. And August 6th, they accepted it, but then they stayed it, which means we accept it, but we want to make a ruling in another case.
Okay.
And that's State versus Irby, and that has to do with the judge that lived outside the district. And it's a criminal case, and so this person who's the defendant for the criminals brings up to the Supreme Court saying, hey, is this judge even good to go? Because the Constitution says you've got to reside, as you and I have already read. But the Supreme Court is staying my case on it, and it's a different constitutional issue.
Totally.
But I don't get why, it does involve judges who are breaking the law. So
Yes.
that way they're the same.
Yes,
But they're breaking the law in different ways.
Right.
You break the law speeding, I break the law without insurance certificate. Do you bundle us together and say it's the same case and wait till Tim gets to say before John? No, but they do it for judges.
Well, here's why I think they're bundling it, is because they're not concerned about the law, the Constitution, or the law as it is written and as it is defined. They're concerned about finding a way to get around those two things.
Right.
And to do that, and it's going to come down in your case too, in Irby, they mention a de jure judge versus a de facto judge. Okay, and so you kind of know about that, so why don't you give a quick rundown on what a
Difference between de jure and de
Right,
facto. So
yeah.
de jure means constitutionally authorized. That means that they're really good to go. They've got all the I's dotted, all the T's gone. They've got the constitutional
Okay.
powers.
So they've met all the they've fulfilled all the qualifications
Yep.
for office.
Yep. De facto
Okay.
means they're wearing the costume. It's like a Halloween costume, right? They come in, they got the black robe on, and they got some defects. That means they haven't done their job right.
Well, but
But
You know, when I
because
was
they
reading
look
in
like
the
a judge,
case-
they smell like a
Yes,
judge. We're going to
yes.
we'll maybe let them go.
but when I was reading the case, they defined de facto like that, except the authority, the deficit, the lack of what they've done. They didn't do something. They're a de facto judge when that deficit is merely technical.
Right. And is violating the Constitution technical?
No,
Right.
it's not.
Warren
That's the big thing.
Warren Spanis said in his opinion to Rudy Perpich, you got to do it. And you got to do it right away in his opinion, December 26, 1978.
Mm-hmm.
When do you need to take the oath? You need to take it right away. You need to, bam.
Right.
And that's not business.
Well, they met, I just got to read this in this Irby case at the appellate level anyway. Is a judge operating under color of law, a de facto judge, is a judge operating under color of law but whose authority is procedurally defective because the acts of a de facto judge are valid. And that was in Wyndham.
Right.
Did you mention?
Wyndham Smallwood, that's the case from 1915.
And of course, that didn't apply, but here they're taking that quote out of context.
Right.
Is,
It's completely out of context. Because as we already know, both those judges resided in Duluth. Both of those judges took oaths. But in this case here, they're trying to apply it to this Irby case, and it doesn't apply.
right.
A point not discussed is not an authority in a case, and that's a basic Supreme Court rule, a basic
Yeah.
case law rule.
Yeah.
But they're trying to,
Okay.
they're playing a little pea
We
shuffle here.
got about 30 seconds left.
Okay.
So-
Well, we missed the money laundering. We'll have to save that for another issue. And we missed
let's
and
come
the
back
child
to-
support issue and
Oh,
all
my
kind of
goodness.
shenanigans that are going on there. So to be
so
continued
much.
to talk about the money
Absolutely.
laundering going on in Judge Carolyn Lennon's court.
This is big news. Do you have a date?
Do I have a date? No, the case
For
has
the
been
Supreme
stayed.
Court, it's
It's
just
stayed
stayed.
right now. It's stayed. So we're waiting to see what
Okay.
happens.
Yeah, we'll come back on that child support, the
Money laundering.
All right. People, thanks for watching. Remember, if you don't stand up for other people's liberties, who's going to stand up for yours? And good men don't do nothing. God bless. Have a great week.
Thank you very much, Tim.
Yeah, thank you.
You bet.